Sorry, let me try. Okay. So let me start again from the beginning so that we can at least get this in perspective. So we said there were a lot of scholars coming right from Greek philosophy who espoused natural law sentiments and philosophies. People such as Aristotle, Plato, Socrates. We also had Cicero, for example, from Roman philosophical perspectives. And there were, again, references to natural law sentiments in the Bible, both the New and the Old Testament, espoused again subsequently by philosophers such as Albert the Great and Thomas Aquinas, who brought a particularly religious perspective to natural law sentiments by saying that it emanated from God, a supreme being, and that this thinking was inherent in human nature. And then we had the school of Salamanca. We had a period called the Age of Enlightenment. And I also mentioned earlier that other jurisprudences also had these inclination. You had the Islamic jurisprudence, Jewish jurisprudence, you had Buddhism, you had Tao, you had Hindu jurisprudence and all kinds of jurisprudence. And then you also had African law, where we had parables, we had proverbs, and we had philosophical and social thinking that espoused what came to be called natural law sentiments. And we said all this concretized into what became the social contract theory. Obviously, how the social contract theory came into being is a subject of inquiry by many jurists and many scholars, of which we'll treat about 4 of them here. And those 4 will be people like Hugo Grotius, Thomas Hobbes, John Locke, and Jean-Jacques Rousseau. Why? Because natural law became synonymous with what you call natural rights. And when you reminded me was when we were at Fela, where we said Fela was saying nobody could give him natural rights. Why? Because he believed that natural rights were inherent in him, and that it wasn't something that could be given by someone, which is why we said Ijalayi cites our frogs as saying, like a harlot, natural law is at the disposal of everyone. Now, I don't know how many of you know of a game called Jenga. I hope you are with me.
We don't know, sir.
You don't know the game called Jenga. Now, it's a game made up of, it's like a board game, not really a board game. It's a game made up of bricks, where all you do is construction. You remove a brick from under and put it on top, keep removing bricks from under, putting it on top. But there's always going to be that particular brick that if you remove the brick, the whole construction collapses. Now, when you look at jurisprudence and you look at the schools of law, one thinking I want you to give yourself during the course of this lecture is, if we say there's something called the Gengar Theory, that there's a particular theory in every legal system, a particular school of thought in every legal system, that if it did not exist, the whole fabric of the legal system will crumble. Which school of thought is it? And why do you think that school of thought takes that pride of place of being the cornerstone, the foundation for legal thought in any particular jurisdiction? We'll have that discussion later. I just want it to be something that you think about during the course of this lecture. Now, we talked about the main premise, and I said, what is the main theme or main premise upon which natural law school is founded upon? The very first one is that in observing human nature, that there are some values that are intrinsic to the human nature. And that application, the application of those values is independent of positive law. When we say positive law, what do we mean?
The law made by the legislature and all of that.
The law made by
the legislature.
By the legislature. Well, not necessarily. Don't let's simplify it to the law made by the legislature. Let's just say any law for the time being in force, other than maybe things, rules of analogy and customary law practices and things like that, but laws that are enforced because they have been effectively, either laws made by the legislature or law empowered by the legislature. Now, if we say that those are the things that you call positive law, because positive law, like we say, is to posit, is to specify that you follow so, and so. And what the natural law school is that there is natural reason that is independent of that process of obeying positive law. Now, some people can say that could be some kind of foundation for positive law, but there are also some arguments. Some people say, well, if you keep behaving in a manner and that manner is being copied and being repetitive, then it starts getting the appearance of some kind of natural law, which in itself is untrue, according to some scholars. So the main thing is that there is a value there are values that are intrinsic to human nature, and that these values are independent of whatever the positive law might be. Now, again, we go to three basic words here, and we use those three basic words for simplification. Now, natural law has come over certain periods. There was a time when there was secular, and because there was generally a secular movement and a lack of reference to a supreme being, you could say that you could have natural law sentiments that were not tied to some divine being. But a lot of the Christian perspective of natural law sentiment was to the effect that natural law was brought down by God, and that God made it the nature of man to be able to identify those laws and to be able to use his natural reason to execute what they called natural laws. Now, we talked about the social contract theory, and we said the social contract theory became much more important. Why? Because across Europe and across some other, there were revolutions at the time where there was a lot of upheaval. There was poverty, there was a might is right syndrome, where you had almost like maybe those cowboy days, the wild, wild west or something, where people just did whatever it was that they wanted. And the very first person to bring the social contract theory into perspective was Hugo Grotius. And Hugo Grotius's idea was that, of course, Hugo Grotius is called the father of international law because of his externalization of the social contract theory. But his understanding of the internalization of the social contract theory was that in most jurisdictions, in most states, what happened was, because life was miserable, there was fair protection of property and certain rights. Citizens gave some of their liberties to government, to a concept known as government, as the ruler, as the governor, and that governor gave people certain rights. And what the people gave back to the government was allegiance. and that formed a social contract theory. Obviously, when we talk about giving allegiance to government, there are different activities that can show allegiance, such as, for example, paying your taxes, following the laws and rules and regulation of government. Other than paying your taxes, obviously, you people are set after law school to do the National Youth Service Corps, which is also a show of allegiance. You do what other thing? So all those are acts of allegiance. And in return, government gives you also certain rights, the protection of your liberty, the protection of your property, the protection of your life, and all such other rights or claims that you may have. So under the social contract theory, this is how the social contract theory became formulated. Government is formed, government gives you certain rights, and then you in return also cede some of your liberties back to government for the protection of those rights. And that was how this was conceived in terms of domestic law. But what Hugo Grotius did was to further externalize the social contract theory also in terms of relationships between states in the international realm. And what he did was to say, look, the states also by mutual consent could come out. And what are the states ceding? The states are ceding some of their sovereignty to enter into an international relationship with other states for protection, what we came to call peaceful coexistence. And so that peaceful coexistence can form a basis for commercial life, diplomacy, consular relationships, any other relationship that you can have in the international realm. I hope we are okay so far.
Yes, sir.
I don't have
Yes, sir.
Yes, sir.
Okay, so that's why we always crack these jokes in my international law class when they were talking about international law. What is it that when the United Nations Charter was talking about the objective of the coming together of nations under the charter, it talked about peaceful coexistence first before it even talked about justice. Okay, so what they were ceding was sovereignty to get protection, peaceful coexistence. And justice appears a little far off in terms of almost appearing ancillary or consequential to peaceful coexistence. But that's the truth as far as I know. So what Hugo Grotius did was to extend the social contract theory beyond just the domestic level and also externalized it. Now, another rendition of the social contract theory was that life, because Thomas Hobbes painted a very aggressive, miserable nature of what life was as a precursor to having the social contract theory. And he said life was solitary, poor, nasty, brutish, and short. And that it was a terrible time for mankind because there wasn't any protection of property, there wasn't any government, there was chaos. And people strived for some semblance of stability in their lives, and they wanted self-preservation, survival. And in trying to get self-preservation, what they did was to surrender some rights to a sovereign for the protection of those rights. You know, when we talked about the social school of jurisprudence, we said there was a laissez-faire attitude. And that laissez-faire attitude, that laid-back attitude of governance was always just to say, okay, you follow these rules and then you avoid sanctions. They didn't look at, government at the time did not focus on having a developmental approach to legal, to the articulation of legal systems within jurisdictions. Now, Thomas Hobbes said the life of the man was solitary, poor, nasty, brutish, and short. And because of that, he decided to search for self-preservation. And in searching for self-preservation, he surrendered some of his rights to a sovereign for the protection of those, for the protection of some of the rights, such as life, property, liberty. And these three rights became synonymous, almost, I mean, they became almost like siblings in terms of what rights human beings thought were specifically inherent and immediate. However, another rendition of the social contract theory was also brought about by John Locke. And John Locke's idea was that no, life was not as brutish as, oh, before I go to John Locke, Hugo Grotius also in talking about the social contract theory and the basic premise, the basic themes upon which the natural law school was based, said that you could have natural law sentiments that were independent of God. And this basically was a response to Christian natural law sentiments at the time. Obviously, you can have arguments relating to it, and the argument will be, does God exist? Does God not exist? If God exists, then it will probably be impossible to have natural law sentiments that were independent of God. But that's a discussion we can have later. Now, John Locke's rendition of the natural law sentiment was again slightly different, because he saw that his idea was that law being mankind's existence being miserable and terrible and all that was untrue, as Thomas Hobbes had said. He felt that life, the life of the man was actually, it was in a happy and glorious time where there was a lot of nature, environment, and that the period was happy. The only problem, of course, was that there was insecurity of property. And this is where we think, when there's insecurity of property, is that not counterintuitive in terms of thinking of insecurity, I mean, thinking of an environment as a glorious and happy period? It's a question.
It is.
You find that contradiction, right?
Yes, sir.
In the same manner, we found contradiction where someone said, even if God existed, where Hugo Grotius said, even if God existed, natural law sentiments will be independent of God. Is that not, because the conception of God is that God, everything starts and ends with God, right?
Yes. Yes, sir.
Yes, sir.
That's just one perspective. But there are perspectives and inconsistencies that I think you will need to take a closer look at, think about, and evolve your own resolution of those problems. Now, John Locke said there was insecurity of property, and that in order to have that security, what citizens had to do was surrender their liberty to a sovereign, while maintaining some inalienable rights, such as the right to life, right to liberty, and right to property. And he warned that the negation of the social contract, the negation of the social contract could lead to the disobedience of positive laws. Who can explain that to me?
Sir, I didn't get the point, sir.
I said John Locke warned that the negation, we already said that citizens, for protection of their what they call inalienable rights, such as right to life, right to property, right to liberty, all these have crystallized under the social contract theory, where they have given part of their liberty and their personal sovereignty to the state. And the contract was for the state to also protect their life, liberty, and property. And I said he warned that the negation of the social contract can lead to disobedience of positive laws. So the question is, what is your perspective on this?
Okay, good morning, sir.
Good morning, how are you?
Fine, sir. So what I think is we all know that social contract is a contract between the sovereign and the people, where the state gives them some rights, while the people, the citizens, have the obligation to obey the sovereign, to do there's a corresponding relationship. So, and one of the obligations of citizens is to obey the positive laws that has been given by the sovereign. So where they go against this social contract, these corresponding rights and duties, it will at one point lead to disobedience of the positive laws, of the laws that has been created by the sovereign for the citizens to obey, to follow.
Thank you very much. Thank you. Any other perspective?
Yes, sir. What is this one? Hello.
Go on, Hamida.
Okay. So my perspective is that the product of social contract itself is positive law. So you're giving people the right to determine the set of laws that govern you and make them. So negation of social contract in a way will mean withdrawal of such agreements, I believe, to be governed by this set of people. So if you are withdrawing your agreements that gives rise to the positive law in the first place, it means exactly what he has said, that negation of the social contract will lead to disobedience of positive laws.
Thank you very much, because when we started, we talked about what are the acts of allegiance. The acts of allegiance, we said, will be, for some of you, the paying your taxes, which is following the law. Act of allegiance, some of the things you do, when you talk about this pleasure and pain principle or hedonistic calculus, you are constantly calculating in your head, what are the things I do, what are the things I do not do, so that you can move towards pleasure and move away from pain. And in this particular instance, what the social contract theory protects is that it says these are so and so things that you must do. Number one, you must show allegiance. How do you show allegiance? By obeying the rules and regulations and the general law. Some of them, you do not kill, you do not steal, you do not dodge your national youth service, you pay taxes, you do this, you do that. Now, if you do all those things, you move towards pleasure and away from pain. And government has the sanction, but there's a social contract theory upon which all that came to be a relationship between you as a citizen and the government. And you look at constitutions, you look at the preamble, what we see is we, the people, have done so and so, have come together to raise up this constitution and all that. Now, if that is the situation, and there are also certain things that government should do, which citizens say government is not doing, that would be a negation of the contract. And disobedience of positive laws will naturally be what will follow. And I think this goes to the grain of especially what happens in Africa. Most people who go to other jurisdictions, other continents, will complain about adherence to positive laws in Africa. When you use a comparative, when you use comparative tools in terms of how people obey laws in other climes. And then we ask ourselves this question. I'm not sure how many times we have asked ourselves in these terms before, but it's been discussed. Is it because of the negation of the social contract?
So I didn't get the question.
Is it because governments, for example, most governments in Africa have negated the social contract? They have destroyed that whole idea of being a social contract, of coming together, of agreeing upon something, good governance that will protect you. We will stop you, your life, we will do this, we will do that. Why do you think, can you relate that to the level of compliance with positive laws in Africa?
Okay, sir, using Nigeria as an example, you said that one of the obligations that we owe to the sovereign is payment of taxes. And in Nigeria, there's this belief that we are not being given, we are not enjoying basic amenities like electricity, good roads, and all of that, that we expect that the government will do from the taxes we pay. So that's why people are reluctant to pay taxes. In fact, they avoid taxes as long as they can. So it could be a reason. I don't know whether my point is clear.
Fantastic point you made, especially as it relates to taxation. Because for me, one of the greatest, in most countries, the greatest crime you can commit is actually tax evasion. And you find out that in the US, most of the great mafia people, like Capone and all that, what they were convicted upon was tax evasion, not even the several murders and whatever it was that they said that they were alleged to have committed. Now, taxation is a key component of understanding the relationship between citizens and government. When human beings are reluctant to pay tax, then a responsible government, irresponsible people will sit down and try to figure out why. Is it because of a negation, a lack of compliance with the social contract? So it's a fantastic example you gave us. And we can go to other aspects of law. It could be criminal law, it can be all kinds of law, but these are some of the arguments under natural law theories. Now, for Ginger Crusoe, because what we're doing is we are trying to build up this discussion to something. Now, Ginger Crusoe was French, and he also was a natural law scholar, and he talked about the social contract theory. And part of the things he discussed under what he called the social contract theory, obviously there was a belief that there was a need to have some kind of social contract between two parties. But where he deviates was that there was a social contract, but that the subjugation of the will, the ceding of sovereignty, was not to any specific entity or government, but the ceding of sovereignty, of your personal sovereignty, your personal liberty, was to the general will. That every unit of society, such as myself, another unit of society will be yourself, and that what you did was to cede part of your liberty to the general will. And the general will mean the will of society as a corporation, as a group, not as a government or as a state somewhere or any of those kinds of manifestation of governance, but to the general will. And that even governments and laws were dependent on the general will for existence. And he says positive laws must align and reflect that general will. Now, as we're talking about positive law must reflect and align with the general will, it will cast your mind back to discussions in sociological school, for example, where we talked about what? The living law. It will cast you back to discussions we had about the historical school, where we talked about the national consciousness, some kind of Vogue's gist. So the more you look at the scholars, even the scholars in different schools. Hello?
Yes, sir.
We can't hear you, sir.
So the more you look at the scholars of even the other schools, your mind casts you back to certain similarities, certain meeting points, and then you start understanding what the deviations are, how this differs from that, and how these differ. And when you get that, that is when you start understanding that you are beginning to process the schools of jurisprudence in the proper manner. And he said, positive laws must align and reflect the general will. If the positive laws do not reflect and align with the general will, that is where revolutions start happening. Because they were schooled in things that happened, such as the French Revolution and other revolutions, and the activities that led to many of those revolutions. You also had the American War of Independence from Britain, where the general refrain at the time was, we cannot be paying taxes unless we are not represented in England. Then why are we paying them taxes? And they said, no taxes without representation. So a lot of that are things that can be attributed to natural law sentiments. So we've talked about Hugo Grotius, we've talked about Thomas Hobbes, John Locke, Jean-Jacques Rousseau. We have also talked about what is the main theme that runs across the natural law philosophies. And we talked about there's a separation from some people of what you call secular natural, what I call secular natural law, and the religious that have religion as a basis, such as the ones in Christendom that are basically propounded by, that are basically advanced by people like Albert the Great and then Thomas Aquinas. But one of the things you have to understand is that there is a wide range of legal thought, philosophical thinking that can still come under the natural school of law without following exactly the same premise. Now, there have been criticisms as usual. Number one, that the whole idea of having natural instincts and natural logic is a myth. Who can explain that? Because I'm sure it's a thinking that may have been agitating your mind during the past 30 minutes. Is there such a thing as a natural logic or natural reason? Or is it a myth?
Actually, for the most part, I'm thinking it's a myth when it comes to natural logic. Because humans generally, they are very irrational and aggressive creatures. So without some certain things put in place, they won't be able to understand the principle of justice, fairness, and all of that. So I feel that natural logic is a myth. It's only when some positive law are put in place that certain individuals are able to to actually fulfill those duties expected of them. So I believe I can.
Okay, thank you. Abdul Razak.
So I don't believe that natural logic is a myth actually, because it is inherent in every human being to know that what they are doing actually doesn't fall in line with human reasoning. For instance, it is said that if we assume that we put 10 persons in a room and we ask them questions one after the other, that is it good to steal? There is like 90% of people will say that it is not good. So what makes them to know that it's not good is not actually not the law, but they know that you are taking someone's property which does not belong to you. You are hindering that particular person. You know that, but you are still doing that at which is wrong. So I can't say that I don't believe that natural logic is a myth. It's actually a reality.
Okay.
Wow.
Someone else?
Yes, sir. I think a way to look at whether natural law or there's something that like natural law, although I feel sometimes I question sometimes the origin anyways, but for us to know that there's something like that exists, I think we should look at children, even from baby stage, before they start learning certain things. There's just a way they know certain things that they are doing, they are not supposed to be doing it, even before any positive law, maybe in form of their parents or things like that. You just find children having certain habits or temperaments. And sometimes when you ask them, okay, why did you do this? A child as little as one can, I don't know, they're just you can depict their temperament from their ages, and you can tell when they know that they have done something wrong, even from a child that is still sucking, biting his mother. Like and they are able to know that, okay, I wasn't supposed to do this. You can pick up temperaments and identify certain natures in children. So I think there is something inherent, there is a seed inherent. It's just the
You do
origin
not
of that
think that it is just analogical behavior where somebody just is copying behavior around them, and that behavior starts getting to be second nature to the human being?
Not really, because if you really observe children, how many certain things they do, you cannot really pinpoint where they pick them. I don't know how to explain. I just think some things are inherent, but the source of the inherent is the question.
Okay, I'll take your word for it a little. But now, okay, now when we talk about things like genetics, we talk about certain things, we talk about psychology and psychiatry. We have all sat down and we have seen people that, okay, Bashira Yahaya, let's have what you have to say.
I'm objective to what Kwajafa said. It's not as if this child learn or have this thing naturally or this is their personality. I'm supporting the view that it's analogical behavior. It's something they perceive from their parents. Like it's some sort of empathy. They feel the expression their parents give to their behavior. That's when they feel kind of sad, even when they bite the mother or something like that. And that's when they know they've done something wrong. So it's not something that comes naturally. It's something they learn from empathy, being observing their parents and people around them and the environment.
Okay, Abdurrahim. Abdurrahim.
Good morning.
Good morning. Okay, let's go on. Now, we've talked about that, and my question is, when you look at the human mind and how the human mind behaves, recently we have had more inquiry in terms of behavioral sciences, human behavior. How do we behave? What are the limits of imitational behavior? Then you look at different things in the human mind, such as psychopathy. You look at antisocial behaviors. Okay, people that are antisocial. You look at all kinds of things. People that do not have an emotional connection to people, and all these people, we have a large volume of research to show that all these people exist, and sometimes they are not in the minority. Now, if, for example, you say that these people that it's not a myth, and I'm playing devil's advocate here. If you say the whole idea of natural reason and all that is not a myth, how do you explain, for example, the behavior of a large section of even our society today? And you have to understand again that it was in this same society they had in Salem, for example, and that is in Great Britain in the old days, they had the burning of witches on the stakes. In some jurisdictions, some types of execution was, it's not now that we're talking about lethal injection for executions and all that. Some type of executions were made to cause the greatest amount of pain before death. And these were from some of the older societies. So the question is, did they not have natural reason then? And why do we feel sorry about executing human beings today? Because we have natural reason that we did not have, say, 50 years ago. Can anybody explain that?
I think
so my question is, my observation is, even while all this is happening and we talk about natural reason today, obviously we talk about the amount of mileage that even relationships between the sexes is having in 2020. And we look back just 50, 60 years ago, maybe less than 100 years ago, when women in Europe were fighting for equality of pay. And up to today, they are still fighting for the same equality of pay. There are BBC journalists who have resigned because being female, they are being paid less than their male counterparts. You have long tennis players who are complaining that their male counterparts are being paid more than just some kind of discrimination on the basis of sex. And these are instituted things that have formed the system in those societies. So the question is, where is the place of natural reason? Because obviously you find the Olympic Committee, for example, the IOC, International Olympic Committee, comes and makes these rules in respect of that, in respect of work, wages, and things like that, and the sanctity of contract and all that. You find complete judicial systems of societies doing that. Where is the natural reason? Let me leave you to ponder on that while we continue. And two, they said, even if it exists, even if natural law, sentiments, principles exist, it is useless. Why? Because they say there are no set of values in terms of executing these natural principles. Any comments on that? I hope I'm not the only one online.
No.
Okay, so if someone says natural law principles are useless because, number one, the execution is tied to values that are different from one society to another society, and that there are so many changes. Let's talk about, we talk about chapter 2 of the Nigerian Constitution. In Nigeria, we talk about it is not justiciable. In South Africa, the perspective is slightly different because you can actually get government to come in and explain why they are not providing housing or not providing so. So you have differences there. And that you cannot have a specific principle that cuts across. You know, when we talked about principles and theories traveling well, that you cannot have principles that cut across a lot of these jurisdictions, and that there are a lot of differences in terms of practice and execution. And because of that, it is useless. Of course, another criticism is that there is no lawgiver. Many of my Muslim brothers and Christian brothers will say, of course, the lawgiver is God, because God embeds that natural reason and natural logic within us. But when someone says there is no lawgiver of natural law, those natural law principles that we're talking about, what they were talking about is the positivist idea of a sovereign, an identifiable sovereign. I think it's important that we have comments on this particular head of our criticism, that there's no lawgiver. We have done only 1 hour. Are you people tired?
No, sir.
Yes.
You are tired. So when someone says there's no lawgiver, obviously that criticism is coming from an analytical jurist of the positivist school. And he's saying, because one of the foundations upon which the positivist school is based upon is that there should be some kind of sovereign. It could be a legislature, it could be whatever. But we have also found out that even though if they say there's no lawgiver, positive law principles, where they exist, can actually be positivized. Sorry, natural law principles where they exist can be positivized. What do I mean? I'm going to nominate someone eventually if you people refuse to participate.
Like those natural laws can be made into positive law, they can be enacted and be enforced.
Sorry, I can't get you. I think there's something, maybe network is messing up with the audio.
Yes, sir. Yes, sir.
What I mean, sir, can you hear me now, sir?
Okay, I can hear you.
What I do from what you said is that natural law can be made into positive law. From being enacted, can be enacted.
I think you are off again.
Sir.
Oh,
Okay, sir.
okay.
So on the no lawgivers criticism against the natural law school, I think what the point is actually talking about is the fact that if we say everybody have natural understanding of the law, so do we have anyone who can actually enforce those classes of laws? And because we cannot trace the origin of that law to a particular authority or sovereign that actually has power to ensure that those laws are being obeyed by the people.
Okay, okay. Thank you. Now, let's move forward. Now, again, they said there is no universality. And that is an argument, I think, that natural law scholars, of all the arguments, that is probably, to me, one of the most deadly of the criticisms, where someone is able to say there is no universality. Now, let me give you an example. If you're talking about some kind of universality of natural reason, when the original Europeans came to Africa, they called Africans savages, right?
Yes.
Now, if we were savages, it must mean that our natural thinking is at variance with the European natural thinking. And bear in mind that the Africans may very well have been calling the European savages too at the same time. So if there's that variance of thinking because of geography, because of biology, because of historical development, then can you have a universality of natural law principles? Because that forms the complete basis of whether you can say you have an inherent reason or logic.
Yes, sir. So
And
on
many
that,
of these Greek philosophers, as a matter of fact, who are saying there's something called an inherent logic and an inherent this and that, were in societies where slavery was being practiced and they thought it was acceptable. I hope we get that.
yes, sir.
Okay, so
Yes,
when we
sir.
talk, for example, we will still go back and have this discussion. If not today, then definitely by God's grace next week. Now, when we talk about the natural law school, a lot of people talk about what has been the impact of the natural law school and the idea of natural law sentiments and all that. Where have we seen that in our laws? And with respect to general impact, we have talked about the social contract theory, embodying the protection of rights to liberty, rights to life, right to property. And these have become some of the rights that we find that have been called fundamental human rights, both as concepts of law and as specific obligations under constitutions of most countries in the world. So that is one impact. Another impact could be directive principles of state policy, which in a way is like entering into a contract with someone and setting a clause for where there can be frustration of some certain aspects of that contract. And you are saying these certain contracts can be frustrated because of what? It could be availability of funds, it could be availability of other resources such as experts and whatever, it could be land, it could be, I mean, if someone is talking about provision of water, for example, then it becomes important that there must be water sources that water can be provided from. If you are talking about accommodation and all that, it also becomes important that you must have enough engineers and enough masons and whatever to be able, that's outside of even funding, to be able to bring that as a realizable thing. And that is why for most jurisdictions, they talk about an incremental development towards the realization of things that are in your chapter 2 of the Constitution. Then when you also look at a third impact could be the preamble of constitutions. And I think the preamble of constitutions basically encapsulates the whole idea of the social contract theory, why we have placed ourselves in the mega law as a precursor to the validation of the mega law. Why? Because we have accepted to come together to raise this set of rules and this set of obligations and rights and claims under the Constitution. And again, we talked about Hugo Grotius's behavior, Hugo Grotius's thesis in terms of the externalization of the social contract theory. And he's sometimes called the father of international law because international law as a law form came into being against the background of his theorizations. And he talks about states coming together and in consensus having international relationships for the protection of peace. And then we also have some other basic some principles. The principles of equity, for example, can be related to natural law principles. we will treat Professor Ejalaye's specific itemization of the impact regarding Nigeria. And there he talks about how it impacts the law of tort, how it impacts administrative law, but even in other places, things such as a jury of your peers bear very resonant natural law principles that you should be judged by a jury of your peers, people that are similar to you from within the same society. Then also there are compensation systems now across a lot of jurisdictions that you can also tie down to the impact of natural law sentiments. Then we talked about the social contract theory. And when we talked about the social contract theory, a warning and aside that we kept leading to was the importance of natural law as it relates to revolutions. When you look at the American Declaration of Independence, 1776, the key thing are the natural law sentiments that were embedded there. In fact, some of these things, particularly when you look at the Biafran Declaration of Independence, the French Declaration and all that, some of those declarations I hope I'm back now. I was cut off right now.
Yes, sir. Yes, sir.
Okay. So we said some of these declarations used particularly natural law sentiments. When the Biafran Declaration of Independence in 1967, it was that our lives, property, and liberty cannot be protected in the northern part of the country. And because of that, we are doing so, and so. And we talked about the American Declaration of Independence from the British. We do not feel an obligation to obey your positive laws, blah, blah, blah. Why? Because you are not giving us the responsibility that is on you has not been actualized. So that is the importance of natural law sentiments. And when we talk about the warning by Gengar Theory that a breakage of the social contract theory can lead to disobedience of positive laws. And we found out that that culminates into revolutions. So the work of natural law has been particularly important in terms of the stabilization of nations and a continuing recognition of the social contract theory. So now we'll be more specific now about Professor Ejalaye. I'm going to try to see how the library can make us have access to an essay he wrote. The essay is a little dated, definitely over 20 years ago, but I have not found an article that best exemplifies natural law sentiments and the impact of those natural law principles in Nigeria. And I think his article forms the basis for a lot of further articles that came into being. Now, Professor Ejalaye says, and I dare say that he taught me jurisprudence and legal theory. Now, he said that there are certain impact, the influence, and he wrote this article in Essays on Jurisprudence, a book, and it was a chapter there where he talked about natural law and the Nigerian experience. And he said some natural law sentiments came about and that the impact was being felt, especially in our jurisdiction, as it relates to, and one of the things he cited was the repugnancy doctrine. What is the repugnancy doctrine? Nigerian legal system.
Yes, sir.
Go on.
Repugnancy doctrine says that any custom or native law that is repugnant to natural justice, equity, and good conscience will be declared not applicable to the situation.
Thank you very much. Fantastic. Now, that is what the repugnancy, and just the whole idea of using the word natural justice shows you the natural law inclination of that particular aspect of our law. And the law exists up till today. Now, there have been arguments as to the phrases are vague. What is natural justice? What is equity? What is good conscience? But those three phrases remain standards for the natural law school's idea of some kind of natural reason. There are some cases where you could also have arguments that the judges that handled these cases were European judges or Nigerian judges who were trained in Europe or Britain and came back to Nigeria and lost that connection with Nigerian customs and started looking at it from the prison, from the eyes of Europeans, and that was why a lot of our customs were deemed repugnant to natural justice, equity, and good conscience. Obviously, there is also argument relating to whether natural justice is one thing or is synonymous with equity and good conscience, or they are separate things having separate meanings. However, outside of the repugnancy doctrine, he also says that the law of thoughts, the concept of reasonableness in things like the duty of care, okay, and the eggshell things called the eggshell or things called concept. Now, the duty of care basically is a user of goods. You owe a duty of care to a user of goods who is using the goods that, for example, you manufacture or whatever. And secondly, that there's something called the eggshell or things called concept, where if, for example, you cause damage to someone, you cannot be hard to say, okay, I just knocked him on his head and then I broke his skull. His skull must be particularly thin or his skull is not strong enough. You take your victim as you find him. So, which is why when many of you young people are flexing muscles and fighting and doing all that, I think people don't have an understanding of some of these concepts. Now, in administrative law, he also cited the Latin maxim, Nemo Judex in Causa Sua. What does that mean?
You cannot be a judge in your own case.
You cannot be a judge in your own case. And he said, these are natural law sentiments, right? And then audio alterem patem rule. What's that?
Hear the other part.
The other side.
That you should hear the other side. And there are biblical and Quranic references to this. Now, there was Cain and Abel, right? Which one killed the other?
Cain killed Abel.
Cain killed Abel. And in the Bible, you will see, I think it's in the Old Testament, where having committed the crime, Cain went into hiding. And God asked him and said, what have you done? So you find out that these principles are so all-pervading that even God that created, that is the Alpha and Omega, that knows the beginning and the end, that knows what he has done, still asked Cain for an explanation. What have you done? Giving him an opportunity to defend himself from his own creator. I hope we understand that.
Yes, sir.
So, and he says some of these are the things. Of course, there are other things. When you see the article, there will be some other things that you can latch onto that are even more than this in terms of the impact in Nigeria specifically. Now, in Britain, because Britain does not have any specific constitution, judges are entitled in Britain to administer the law contra bonus et mors, basically, which is that anything that is against, they have the right to follow rules that are moral, rules that deviate from, rules that punish anything that deviates from public morality and all that. But because they don't have a constitution, there's a slightly larger latitude in terms of how judges can give judgments. But in Nigeria, we have a constitution. So other than having a constitution, we have the hierarchy of courts embedded in the constitution, and then the allegiance to specific legislations and specific principles of law. So the way in Nigeria, the way judges are obliged to make rules and pronunciations will be slightly different from in Britain, for example. And then he itemizes some of these things in that article. So when you see it, you'll be able to understand the larger impact. Now, has Dr. Mrs. Raji treated you? Has she taken African law with you?
No, sir.
Okay, she will probably be doing that next week. I was hoping she had done that so that we can find if we can have a discussion regarding whether there are alignments between African law and natural law. But we can just do 1 or 2 minutes of that. Now,
Yes.
how many
Yes,
of
sir.
you have
So
any
he actually talked about African jurisprudence to an extent too. It's in our note too.
You said what?
She actually talked about it, but I feel maybe you may still have some things that you add.
Okay, no, I'm not the one adding anything. It's you people that are going to teach me what she taught you. And what I really want is, while you were having that discussion, could you find anything in African law, African principles? It could be through preambles. It could be through poetry. It can be proverbs. Have you found any that you think is related to natural law? You are taking a second to think about it. It's over a second now. Now, for me, one of the things that we tout as Africans as being of the greatest importance in terms of our conception of an African law is that we give primacy to reconciliation rather than sanctions, right?
Yes, sir.
Now, if you give primacy to reconciliation rather than sanctions, would reconciliation not be more in terms of a natural law than punishment? I'm not getting any feedback. Do you think reconciliation is more in tandem with natural law sentiments, or do you think punishment is more in tandem with natural law sentiments?
Punishment is more in tandem with natural law sentiments.
With natural law sentiments.
Yes, sir.
Who differs?
I do, sir. I think punishment is much more related to the positivist school of thought.
Someone else?
So I think that the idea of maintenance of peace is what is in tandem with natural law. So it now depends, because I feel also natural law has aspects of punishment. So it depends on which will bring a more peaceful or resolute settlement. So if reconciliation would apply in a case where it is reconcilable, like, okay, somebody has maybe in contractual cases or something like that, then reconciliation will be used. But if it is punishment, like for deterrence and other things in the society, then what are we talking about? Punishment will be used.
Okay, any other perspective?
So I agree with what Amita just said. Reconciliation and forgiveness is more in tandem to natural law, because that's what they breed, that's what they talk about, forgiveness and reconciliation. So punishment is more in tandem to like the other school, which is the African law perspective.
But that, I don't think that's what Hamida said. Was that what she said? Hamida, can
Yeah,
you
she said
clarify?
peace.
Okay, so I'm saying that just the maintenance of peace and harmony in society, like the fact that there should be no discord, is the sentiment of natural law. So whichever one would apply to maintain this as best as possible would be used. So I feel they can both be seen to be natural law sentiments to an extent, depending on like the circumstance which is applicable. So it depends on which would resolve a dispute in a less disharmonious, I don't know, I'm sorry, I'm not picking the right words, manner as such. I don't know if it's clear.
Thank you very much. The reason I wanted you to clarify was when he was explaining, she came across to me like some kind of green grace under green grass who did not want to give me a yes or no answer, but created this environment of, okay, if it is this is more in tune with natural law. If it is this, it is more in tune with positive law, because if you are talking about sanctions and all that. But again, she started talking in terms of if it is, say, the law of contract or something that has been infringed, if some contract relationships have been infringed upon, then obviously reconciliation will be fantastic and be more in tune with so and so. But if it is, I mean, if you are talking about a crime code or whatever, then it will also be more in tune with the positivist whatever, but it is not, it's not a diversion from natural law sentiments. Do I get you right, Amida?
Exactly, sir. Yes, sir.
Good. You know, when we are having a discussion and someone is saying, okay, yes, I know. The other time, I think that we had this lecture where one of you was saying, let me just get this straight. You said so and so, and I nodded. And he said, you said so and so. I nodded the second time. Then he said he said something else, and my thinking was just, okay, this guy got me today. He's going to hit me with one bloody inconsistency, and I'll just start sweating. And he said, no such thing, that he came in peace. Now, this is the beauty of jurisprudence. Number one, the fact that we do not have a yes or no answer, and we still have an understanding. The fact that we can talk in terms of context. If it is civil law, this will be my opinion. If it is criminal law, for example, in terms of sanctions, this will be my opinion. And I think that is what makes this whole discussion so important to us as a generation of students. Because there are certain things, and it can appear in Africa, for example, we can have something that we say, okay, these are natural law sentiments. Let me give you an example. That a man should marry a woman will be a natural law sentiment in Africa, in most of Africa, apart from maybe South Africa, right?
Yes, sir.
Yes, sir.
Now, don't you think exactly the same thing would be natural law sentiments across some parts of Europe? where if you deviate from it, you appear to be bereft of some natural reason.
That's true, sir.
Okay, I thought you people were reluctant in answering, and I said, okay, they are becoming suspicious of me now. So our argument is this: if two diametrically opposed concepts are viewed as being natural law sentiments from two diametrically opposed jurisdictions, then, as Biafran said and cited by Professor Ijalaye, is natural law not a harlot at the disposal of everyone?
It is.
Because, you know, when we also talk about the critical legal studies, and someone, one of the scholars there said, in fact, it is the people that are giving judgments on specific interests by specific groups. They are the ones that come out and entrench this whole idea of we are following logic, and they continue. I mean, that they are following the rules as laid down for interpretation of statutes. And they state it repeatedly that it is those specific people that and in a way you find out that for natural law sentiments, when we talk about natural law sentiments, we found out that sometimes something that was natural law 30 years ago may not be natural law today. In terms of generating principles, there are certain standards. Number one, that there should be good relationships among states. There are certain things that, as the sanctity of life, for example, right? But again, there are a lot of things where there are deviations by people who still espouse natural law principles. I hope we understand.
Yes, sir.
Now, can someone tell us some proverbs or whatever that are African in nature that you think you can link with natural law principles? Because we want natural law principles to travel well. Or you people have become so Europeanized, you don't even have local proverbs. You don't know any local proverbs anymore. Is this what WhatsApp and the internet has done to you people?
I think I know one, but I'm not kind of sure of the pronunciation at some point.
Just say it. We'll try to get the gist.
Okay, Yoruba say, Ọmọ burúkú ò ya bùsàn. Sorry, ọ̀gẹ̀dẹ̀ dúdú ò ya bùsàn, ọmọ burúkú ò ya lùpá.
Okay, what does that mean?
I think it means that no matter how bad a child is, something like that, you cannot
disown such a child.
Like yes, no matter how bad that child is still your child. Something like that. And
you know, this even goes beyond law, because right now I look at it from the perspective of a natural concept. You are talking about a relationship between a parent and a child, and how that relationship should be. You know, so for example, and you can find out that if there are jurisdictions, you can transmit something like that to the relationship, the conjugal relationship between a man and his wife, for example, where you have a general rule where the wife cannot give evidence against he's not obliged to give evidence against the husband or whatever, because that relationship is seen as sacred. And you can, from your statement too, you can find that biological connection between a parent and a child, that of protection, protecting his life, leading him in the right manner without abuse and all that. And we have all that. And there's another one someone told me the other day, something like if you compare two children, you beat one to death.
Yes.
Thank you very much. I think that was exactly how the guy told me. Now, what that basically means is each according to his own capacity. And you can also look at these things as natural law sentiments. So when we look at natural law sentiment, it's important that we look at it from different perspectives, that we don't just look at natural law sentiment as a European iteration of what that particular group of, that particular school of law is, and then we just see things from the perspective of writers in what is called the global north. Why? Because there are also people from different civilizations that have talked about natural law sentiments. And already right now, we've been able to identify a few. And I'm sure given more time, we'll be able to link African law in a very robust manner with natural law sentiments. Now, we still have criticisms relating to whether natural law sentiments exist or not. And some people say it is just imitation, and then after a while, imitation starts giving you this habit of something being instinctive and intrinsic to you. You know, so a lot of that thinking, obviously, you can find time and then do them yourself, hopefully before we meet for next week. Any comments, observations before we round up? Okay, if it's a little tough for you to think of a comment now, we'll deal with all that next week. So I expect that you spend the weekend in reversing and thinking. Then we can have a general view of what I have taught you on the schools. So we can have a general review of what I have taught you about the schools of jurisprudence next week. Then we can also talk about, I told you we could sit down and talk about exams in terms of how we can mitigate some of the, well, not mitigate some of the information that we have, how we can just narrow our scope a little so that we can focus on specific things, do a little review on those one or two things, and then have a general idea of, if, for example, you are talking about examination purposes, how do you address things? Because sometimes I get the impression that if somebody gives you 6 points, people look at it from a marking scheme perspective, where you look at 6 points and it's like, okay, if I mention those 6 points, I've gotten the full marks to that. Now, one of the first things we told you about jurisprudence and legal theory is that there isn't a yes or no answer. Obviously, there are some headings and a structure upon which you should have a discussion. But because there isn't a yes or no answer, you will not be able to utilize a marking scheme in the same manner I believe you will utilize a marking scheme for, say, constitutional law or law of evidence. So it's important that we have that at the back of our mind. It's like mathematics, for example, where it's not the answer that gives you your points, is the different levels of calculation that gives the points before you get to the final resolution or answer. So hopefully we'll be able to do all these next week. And if there are other concerns or challenges that you think you have, please bring it to the table and then we all take a look at it together. So have a nice weekend and I wish you well.
Thank you very much, sir.
Thank you, sir.
Thank you, sir.
Bye-bye, sir.
Bye,
Have a
sir.
nice day. Bye-bye.
Ah, my brother.
Julius.